still waiting for some testing.
Jermaine Young, 240916. I decided to quit saying DCCR. I'm over it. It's too much. All right, sir, you Jermaine Young?
Yes, ma'am.
And Mr. Young is charged with aggravated sexual assault of a child. And Mr. Burbank, what is the...
Notice how much weight is being placed on a single DNA result. In court, this isn't just a detail, it's the cornerstone of the entire case. Without it, the defense can argue there's nothing solid to move forward on. Would you feel comfortable if your future depended on just one test result?
Announcement.
I think we're still waiting for some testing, Judge.
We are, Judge. I put a call in. I got a response on my DNA. That's the only thing that we had at CPS. We've received that.
Got that.
So this is the only thing that we're waiting on.
Did they give you any type of...
All through with them.
All right, let's do, we'll do, now that we've got CPS, that's the only thing we're waiting on. I'm going to do 60 days. And then hopefully we'll have some information, obviously when it gets close, if you can get back with them and see where we are. If we need to let them know of some special setting to make it move up, then we'll see if we can get that done.
Yes, ma'am.
Stay in touch with Mr. Burbank. He'll let you know when you need to be back.
Yes, ma'am. I can't tie it.
It's all right, you're good. All right, are you Maverick Neal? And Mr. Neal's charged with aggravated assault with a deadly weapon in 24 DCCR 2436. And what is the announcement?
Judge, we'd reset for me to try to contact the complainant. I'm not getting any answers for written correspondence or the different phone numbers my investigators know to locate for. But I'm not inclined to dismiss because of the seriousness of these charges, Judge. I've made a probation offer, which I believe is going to be rejected. And if that's the case, I guess we're set for trial, and I'll could double our efforts to locate her.
And you intend to go forward with or without?
I believe I can prove the case without her presence, Your Honor.
Okay, so if, sounds like there needs to be a rejection done, if there's not going to be, if he does not want to accept.
That's a massive gamble. Take a 5-year probation deal or risk up to 20 years behind bars. This is the heart of plea bargaining freedom with conditions versus the uncertainty of trial. If you were in his shoes, would you roll the dice?
Any plea agreement, let's get the rejection done this morning. That's on the tablet, and then I'll call you back up when I'm ready to take care of that.
Anthony Whitmire.
All right, so Mr. Neal, in cause number 242436, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, I do.
And I have here on the computer plea bargain rejection that you've signed with Mr. Doyle. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your case, for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. And with that type of probation, if you successfully completed it, the case would be dismissed and you wouldn't have a felony conviction. Do you understand? So I want to make sure that you do understand everything, because it's very important that after today, if I put your case on the trial docket, I won't accept this plea agreement. All right, so if you want the plea agreement, fine. If you are not guilty and you want to have a jury decide, that's fine as well. Mr. Nichols has stated earlier today that he intends to go forward with or without the complaining witness in this case. So we've talked about that. I don't want you to think that at some later date he intends to dismiss the case or something would change unless there's new evidence that comes forward. So if you don't want to take this 5-year deferred probation, that's fine. We'll put it on the trial docket, but I want you to make sure you understand that I will not accept this agreement after today. If you change your mind later and you want to enter a plea of guilty, then you can plea open to the court or to some other plea agreement. Do you understand that? And do you want to reject that plea agreement and have your case set for trial? It's your decision.
Sorry.
I mean, go ahead. I mean, if y'all need to talk some more, but
You don't want to plead, correct? Yes, you want to plead, or no, you don't want to plead? That's what we've been talking about outside. Yeah.
so you've been talking about it with Mr. Doyle.
Because I'm not understanding
What are you not understanding?
it's been 4 times, right?
I don't know about 4 times.
He's talking about the docket calls.
Okay.
The state had indicated to me that they might have, or I indicated to the state rather, that the victim didn't want to prosecute the case.
Right.
He's never been able to get a hold of the victim.
Right.
To have her tell him that. he feels like he's been up here enough that I have the authority to make the state dismiss it, and I don't.
No, correct. So Mr. Doyle is doing everything he can with trying to negotiate with the district attorney. And it is legally possible for the state to go forward with the case without the complaining witness, and that is what they intend to do, according to Mr. Nichols, correct,
Yes,
Mr.
Your
Nichols? So with or without her, they're going to present the evidence that they do have to a jury, if you go to a jury trial, and then that jury can decide whether or not you did or didn't do what they're charging you with. So today is the day to decide if you want to go to trial and let that jury decide whether she comes or not, case isn't getting dismissed, or if you want to enter a plea of guilty to the offense for that 5-year deferred probation. So you want to have a jury decide. Then I will place your case on the trial docket.
I need to determine the restitution on those misdemeanors as part of the plea, if there's any.
Good morning, sir. Are you James Ward?
Yes, ma'am. Good morning.
And Mr. Burbank, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Ward, in cause number 240541, you're charged, the state has elected to proceed on the lesser included offense of a second-degree felony offensive robbery, and that's from April 11th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to pay restitution that would be determined between now and when we come back for sentencing, and there would be dismissals in the misdemeanor cases. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection to one.
It's admitted. Any evidence that Mr. Ward's not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll figure out restitution, and we'll come back later for sentencing. Yes, sir.
Your Honor, there's a case that was received by our office just a few weeks ago, not yet indicted, for evading with a motor vehicle. The offense date is from December of '24.
Okay.
Should that case get indicted, we will be running it concurrent with this.
Okay. If
I
it
don't
gets
think, I don't think a decision's been, or I don't think it's been presented to the grand jury yet.
All right. So obviously, if that case gets indicted, the understanding is that you would come in, we would do the same thing on that case, and you would have a probation that would run at the same time as this one. Is that your understanding?
Yes, ma'am.
All right. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there, okay? We'll see you back at sentencing. Yes, sir.
Thank you, Your Honor.
Michael McCain, and good morning, sir. You are Michael McCain? And Mr. McCain, Mr. Vasquez is here for Mr. Macon, and have you had an opportunity to go over that PSI with him? And are you?
It shifts from law to empathy instead of hammering punishment. He's highlighting rehabilitation and even dangling early release as motivation. It's a reminder. In some cases, the courtroom isn't just about guilt, it's about second chances.
Okay, going forward today with your sentencing with Mr. Vasquez. And I've received that pre-sentence report. This is 241408. Has everyone had an opportunity to review that report?
Yes, Your Honor, just read.
Are there any additions or corrections to that?
No, Your Honor.
All right, Mr. McCain, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for a period of 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, and there's no reason for me to think you won't, this seems like it's something that's very out of character for you, and also something that even you admitted was because of some emotions that had to do with your child and ex and things like that. Obviously, you understand now this isn't the way to handle that, correct? If you do everything you're supposed to on this probation, it's an excellent opportunity because you don't have a felony conviction. When you successfully complete it at the end, the case will be dismissed. You'll never be a convicted felon. The other side of that, though, is if you violate your conditions of probation, you can be brought back into court, you could be found guilty of the offense, so you would be a convicted felon, and you could go to prison for up to 20 years because of this. Do you understand? Also, I want to make sure you understand as well, you got a 10-year probation. However, I sign every single day early terminations for people to get off probation early. And so that could very well happen, it looks like, with you. And if you do everything you're supposed to while you're on probation, get your community service done early, follow all of the rules, don't test positive for anything, don't obviously get arrested for anything else. Anyway, do everything you're supposed to, then you would be eligible early to get off probation. So make sure you do all of that and you don't have to worry about the whole 10 years. If you're not doing everything you are supposed to, then obviously you could end up on it for 10 years or you could end up with a revocation. You understand? All right, I'm handing you the trial court certification. It shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over all of your paperwork. All right, good luck to you, sir. Thank you, Mr. Vasquez.
Thank you.